Hello everyone. Today's topic is PI proceedings in Germany, what's new? According to recent case law of the German Federal Constitutional Court, which is of high relevance for IP matters in Germany as well. So I'm here with my colleague Philipe. Before we go into details of that case law, could you give us a short overview of PI proceedings in Germany?
Well, in the field of trademark matters, design matters, but also unfair competition law, PI proceedings are of very high relevance. A PI may be obtained within a few days, sometimes even within a few hours. So obviously, as an applicant of such a PI request, this is a very high interest and is also very cost effective. It was also common practice that if a judge receiving a PI request, if he has some questions or maybe even if he's of the opinion that he will not grant the PI, he would rather informally contact the applicant and tell him about his preliminary view on the matter. However, this has changed and we will come to that in a little bit. How about in the field of patents?
Well, you can also obtain a PI in patent matters, however more rarely than in trademark, design or unfair competition.
Why?
Due to the complexity, in particular the technical complexity of the case, including infringement, but in particular the validity assessment. Moreover, there are differences between the relevant patent courts in Germany, such as the proof of validity and, in particular, the urgency requirement.
Indeed, the urgency requirement, that's absolutely the same in the field of soft IP.
Yeah. So, could you maybe now briefly summarize the case law of the German Federal Constitutional Court that we just mentioned in the beginning?
Of course. There have been two decisions of the Federal Constitutional Court already rendered in September. We reported about it in more detail in our IP report of December. And these decisions concern press law, but among experts, it's clear that the impact of that decision will go far beyond press law, and in particular, it would also concern IP matters. So according to that two decisions, if a PI would be rendered without a prior warning or other involvement of the respondent before rendering the PI, this would violate the respondent's right of equal arms, which is equivalent to a fundamental right indeed.
I do have one follow-up question. Does that necessarily mean that you always have to send a warning letter to the alleged infringer? In particular, if you are on a trade fair, which usually lasts only 2 to 3 days, if you want to avoid an oral hearing?
That's a very good question, Stefan. I would recommend, if you want to be on the safe side, you may want to give at least an oral warning to the person at the booth of the trade show. However, we are also of the opinion that under certain circumstances, courts would still be prepared to grant an ex parte PI, which is in particular the case if you want to seize goods at the booth.
Thank you for your attention. For further details on PI proceedings in Germany, please visit our website.
And don't forget to check our IP report on these two interesting decisions. Thank you.